Hi, everyone, and welcome to this session on client and matter risk assessment. My name's Declan Brown, and I'm joined by my colleague Michelle Clement, and we are both anti-money laundering regulatory managers within the AML proactive supervision team here at the SRA. As part of our roles, we carry out on-site AML inspections at firms. The purpose of these inspections are to assess how firms are compliant with the money laundering regulations. Where we identify good practice, we take this away and we share it with the industry. And where we identify any weaker areas, we try to work with firms to help improve compliance. Our team are also responsible for carrying out and leading on AML thematic reviews. So some of you may be aware that Michelle and I actually gave a talk on client and matter risk assessment at last year's Corp Coffer conference. Our guidance and our template have now been available for just over a year. So we thought we'd take the opportunity today to speak to you a bit around what we found over the course of the last 12 months, as well as some frequently asked questions that we still get around client and matter risk assessments. Before we get into it, I thought I'd just touch upon some of the resources which are available to you. As I've just mentioned, we have produced a client and matter risk assessment template alongside some guidance, both of which are available on our website. If you do choose to use our template, we would encourage you to adapt this to your firm's specific needs. We've also produced a number of webinars on client and matter risk assessments. These are available on both YouTube and on our website. And finally, we have produced a warning notice which sets out our expectations around client and matter risk assessments. We have and we will continue to take action against firms who fail to document client and matter risk assessments.
Thanks, Declan. So we're going to start with this slide on why it's important to properly risk assess your clients and your matters. The primary reason is that failure to do so can expose your firm to the risk of abuse by criminals. And aside from the fact that it is a mandatory requirement under the money laundering regulations, there are lots of benefits for carrying out risk assessments. So the first is a risk assessment will help you to identify and understand the money laundering and terrorist financing risks that a client or a matter might present to your firm. And this in turn will help you to decide whether you wish to accept the client. It will help you to understand if the client or the work involved is outside of your firm's risk appetite. If you choose to accept instructions from the client, a client matter risk assessment will help you to determine what level of customer due diligence you need to undertake and any additional steps you may wish to take to mitigate the risk that's posed. Another benefit of properly risk assessing client matters is your firm's reputation. If criminals are aware that you ask too many questions, they might be put off from using your firm, and it might be easier for them to use a firm that doesn't ask quite so many questions. Lastly, a risk assessment can also be a useful tool to understand your firm's exposure to financial sanctions risks. This, of course, is not intended to be an exhaustive list. Okay, so what have we seen on client matter risk assessments 1 year on? So you note that from the screen that between April 2022 and April 2023, we found that 21% of files reviewed in that period did not contain a client and matter risk assessment. This figure has dropped to 19% between April 23 and April 24. So this means that 19% of the files reviewed between April 23 and 24 did not contain a client and matter risk assessment. And while this is not a big drop, it is a positive shift in the right direction. The second set of figures there speak to the effectiveness of the client and matter risk assessments we reviewed. To determine effectiveness, we considered factors such as whether the risk assessment considered money laundering risks as opposed to, say, business risks. Did the risk assessment assess client risk and matter risk, or just one? And was the rationale for decisions made on the file clear? These are just examples of some of the things we consider when we determine whether a risk assessment is effective or not. So back to what the figures tell us. So on the files that did contain a client matter risk assessment, we considered that 51% were not effective between April 22 and April 23. And 1 year on, between April 23 and April 24, I'm delighted to report that this figure has dropped to 12%. In essence, only 12% of the client matter risk assessments we reviewed were not effective in comparison to 51% the previous year. And we acknowledge that this is a big drop, which suggests that our guidance has landed well with the profession, and it is a testament to the hard work you've all put in to comply in this area. So well done to you all.
Thanks, Michelle. So we thought we'd touch upon some of the good practice that we've seen over the course of the last 12 months. And some of the best examples we've seen are where the matter risk assessment form sets out the various factors which fee earners must consider when assessing client or matter risk. And this helps to provide guidance to fee earners around what level of due diligence is required. We saw some really good examples of client and matter risk assessment forms which were tailored to the firm's specific risk exposure. So, for example, we saw some firms who made use of our template and they'd added questions which were specific to the types of clients which instructed their firm. We were pleased to see that client and matter risk assessments were reviewed reactively when additional information about a client or a matter was received. So, for example, when funds were received on a matter, the risk assessment was reviewed to ensure the source of funds was consistent with what the client had previously explained to them. And finally, we continue to see a collaborative effort between fee earners and risk teams to assess risk. We saw some really good examples where the initial risk assessment was carried out by the fee earner before being passed on to the compliance team to review. And this provides an opportunity for the compliance team to review and highlight whether any additional information is required to help mitigate the risks.
Thanks, Declan. So we're going to use the next couple of slides to answer some of the frequent questions we receive on client and matter risk assessments. So the first question I'm going to address is whether a client and matter risk assessment risk level needs to be the same as the risk level allocated to a work area in the firm-wide risk assessment. So the example used there is if the firm-wide risk assessment rates conveyancing as high risk, can a conveyancing matter be rated as medium, or does it also have to be high risk? So the money laundering regulations require that your assessment of the level of risk in a particular case needs to reflect your firm-wide risk assessment. So using the conveyancing example here, if the firm-wide risk assessment considers conveyancing to be high risk, this should be the person completing the matter risk assessment starting point. So the risk level should be updated to reflect the specific risk or factors that are considered in the matter as the matter progresses. So as an example, if an initial risk assessment rates conveyancing as high risk because the firm is yet to verify the source of funds that's been used to purchase a property, when the source of funds have been verified, the high risk rating may then be adjusted to reflect how the firm has mitigated the risks initially identified.
Thanks, Michelle. So another question that we quite often get asked is, when am I required to do a client and matter risk assessment? And feeding into that, is it absolutely required to have a formal document to show compliance, even where my files confirm source of funds, ID, etc.? So for any work that's in scope of the money laundering regulations, you must carry out a client and matter risk assessment. And this is a mandatory requirement under the regulations and is required in addition to carrying out client due diligence and, where necessary, source of funds and source of wealth information. The AML FAQs page on our website does provide some guidance around in-scope versus out-of-scope work. So please do take a look at this if you are a little unsure on whether work falls within scope of the regulations or not. Client and matter risk assessments should be done towards the start of a client relationship or towards the start of a matter. The sooner you carry out your client and matter risk assessment, the more time you have to mitigate the risks. As we have mentioned in the past, if matters for one particular client are highly repetitive in nature, where the risks remain consistent, you may choose to do an overarching matter risk assessment form, which outlines the risks and what you plan to do to mitigate them. You should, however, ensure that this is regularly reviewed by your fee earners so that they can identify any new risks and take the appropriate steps to mitigate them.
Thanks, Declan. So we often get questions around whether a client and matter risk assessment should be combined or conducted separately. So there are no hard and fast rules with this. The regulations only specify that client matter risk assessments must be assessed, but it does not specify how it must be done. And we have seen firms doing risk assessments in a variety of ways. Some firms assess clients separately, then matter risk separately, or both combinedly. Some firms complete risk assessments on paper, some have it integrated into their case management system. The important thing to note here is that a client risk assessment should identify and assess the risks posed by a client, and a matter risk assessment should focus on the specific factors that a matter presents, which is different to or beyond what you've already identified in relation to your client. And how you choose to do that is up to you.
Thanks, Michelle. So this is a really interesting question that we have received in the past. Where there is a suspicion around a client or matter, do you expect to see details noted on the client or matter risk assessment? For example, where reports have been made to the Money Laundering Reporting Officer or to the National Crime Agency. So, in circumstances where you are considering reporting to the NCA or to the MLRO because you have formed a suspicion, we would suggest that you do not record this information on the client and matter risk assessment form just to be safe. What we would suggest and what we would recommend is that you record a note on the risk assessment form which says to speak to the fee owner who is handling the matter. Anyone who's then working on the matter can then check in with that fee owner to see what actions they should take.
Thanks, Declan. This last slide is just a shameless plug, really. It's just to say that if you choose to use our template, we would really encourage you to tailor it to reflect any specific risks your firm may be exposed to. And we have seen some very good examples of our template being used in the last year. We would also really encourage you to read our client matter risk assessment guidance, which is on our website if you haven't already. It is a very helpful tool for firms because it contains good and bad practice examples that you might find useful. And I'm not saying that because I'm biased or anything.
We always appreciate your feedback, and in the description below there is a link to our evaluation form. Further resources can also be found on our website. Thank you.
Thank you.